Morning.
Good morning.
Good morning. Good morning and welcome to an oral argument session of the 5th District Court of Appeal. My name is Judge Rand Wallace and I am the presiding judge here today. Joining me on this panel this morning is Judge Richard Orfinger from Volusia County and Judge Dan Traver from Orange County. We have one case on the docket this morning, and that is Robert Kennard Bavell versus the state of Florida. Each party has 20 minutes, and I'm going to assume from the appellant that you would like 5 minutes of rebuttal unless you tell me otherwise. And with that, I will invite the appellant to begin when you are ready.
Thank you, Your Honor. May it please the court. My name is Charles Fletcher. I represent Robert Bavell in this appeal. And I would like to go to begin my presentation with my second issue in this appeal. And that is, Your Honor, that the trial court abused its discretion, summarily denying the defense request to clear the courtroom for a witness to testify after that witness informed defense counsel that he was in fear for his safety. As you know, this is a murder case. In this case, defense counsel told the jury in his opening statement that this was a case about self-defense. Mr. Bavell, the defendant, was in fear for his life and his safety. In any trial, but in particularly in a homicide trial, the defendant has a fundamental right to present defense witnesses that can corroborate any fear that the defendant was in, that Mr. Bavell was in prior to the incident in relation to the victim, Mr. Sullivan. The witness, Alvin Damon, informed defense counsel prior to taking the stand that he was in fear of testifying before the court. If I can quote from the trial testimony, the defense attorney said, and I believe this is significant because it does preserve this issue. Your Honor, there is a witness that we're going to call this afternoon, Alvin Damon. He is concerned about his safety. And then the trial attorney, the defense attorney, reminds the court of what had happened just previously in the courtroom this morning. And that was there were texts being sent to the defendant's mother from a friend of the victim, threatening texts going from one side of the courtroom to the other. There were several outbursts where the court had to tell the gallery to either refrain from making comments or leave. So again, he asked that this witness, who was friends with Mr. Sullivan, the victim, and friends with Mr. Bavell, and knew many of the people in the gallery, the defense attorney said, can we have his testimony without the gallery being present? The court simply said no. And then when the witness, Alvin Damon, took the stand, the defense attorney renews his request, says, Your Honor, as far as being able to clear the courtroom before the testimony, the court said, so noted. There was no inquiry by the court as to this witness's fear of the people in the gallery, and the resulting impact on Mr. Bavell's trial was
Counsel, why was it the trial court's obligation to ask what the specific nature of the witness's fear was? Wasn't it the obligation of defense counsel to raise that issue?
Judge, he stands before the court and he says, Your Honor, I have a witness who is afraid to testify. Can we clear the court? And then the court immediately shuts him down. And under the case,
based on that particular record, could he have been scared of testifying because he had a fear of public speaking?
Judge, under Lewis, when a defense attorney, the case I cited in my brief, Lewis, under that case, when you bring to the court's attention that a witness is afraid to testify, and it doesn't have anything to do with public speaking or anything like that. When he's afraid to testify, the judge must make an inquiry, and failing to do so is harmful to the defense. And I will, if I can continue, Your Honor, here's the result. You end up with questions like this. Defense attorney asked, did Mr. Sullivan make any threats towards Mr. Bavell? and that the witness sitting there says, "I don't recall." A little while before that, in a deposition, that same witness said Sullivan made threats via Facebook Messenger, and I screenshot them and I sent them to Mr. Babel. Mr. Babel told Damon, the witness, that Sullivan was calling him, was threatening his mom, was trying to take pictures of where he lived, had said that he was going to hunt him down and beat him up. Those are significant actions. This witness, Damon, is friends with both of these individuals, and he's relaying the threats from Mr. Sullivan, the victim, over by screenshot, by conversations, over to Mr. Babel, which all plays into critical defense testimony that goes to the state of mind of the defendant at the time of the shooting.
Mr. Fletcher, what evidence did you have that you presented in the trial court that closing the gallery for this witness would have rendered the witness's testimony more effective?
Judge, there was no evidence presented to it other than defense counsel's obligation to ask the court to clear the gallery because his witness felt threatened. And then the court shuts him down, says no. And then when he asks a second time, he says noted and moves on. He does not allow the defense attorney to put somebody up on the stand to testify about the fear. But even putting Damon on the stand to testify about the fear would not have worked because the gallery was what he was afraid of. You have to clear the gallery out to be able to have this witness be able to testify because he was in fear.
And Mr. Fletcher, what is the information or proof that you provided to the trial court that clearing the gallery was the only way to protect your client's right to a fair trial?
Judge, I don't know how else to do it. Because the trial court shut the defense attorney down, I'm left with no ability to show that. Mr. Damon said he was concerned about his safety, not about public speaking. But because the court never inquired into it, didn't even ask the defense attorney for anything specific, just no inquiry whatsoever, the record now is absent. We have no record of what happened.
So is there any burden on you, Mr. Fletcher, or defense counsel at trial to proffer any type of evidence or any type of concern to the trial judge in order to give the trial judge more detail than just a general fear, as Judge Traver touched on, about testifying in the trial?
Well, Judge, it wasn't, defense counsel didn't say that there was a general fear. He said he was concerned for his safety. And under Lewis, when defense counsel puts that out there in front of the court and in front of the gallery, who are all listening to it, he is putting that witness in further fear, in my opinion, because now the gallery's paying attention to it. Why is he afraid of testifying in front of me, Sullivan's friend, the victim's friend on this side of the gallery? So defense counsel put the court on notice, and it's incumbent then on the court to protect the defendant's right to a fair trial and have that weighing of the defendant's right to a fair trial to present testimony versus the public's right to watch the proceedings.
Is your request on issue 2 predicated necessarily on the communication to the mother and the unspecified comment from the gallery?
Judge, it's not just predicated on that. It's that.
If that, let me ask a better question then, counsel. If that wasn't there, is issue 2 still an issue?
Yes, it is, Your Honor. Yes, sir.
So anytime, to understand your argument, anytime somebody comes up and says, I have a witness who's concerned about their safety, the trial judge has to stop everything and decide whether or not they're going to clear the courtroom?
At the very minimum, the judge needs to inquire of the witness. So yes, you inquire of the defense counsel, but in this case, he just shuts him down. But under Lewis, you're supposed to inquire as to what's going on, why the witness is in fear, what's the reasonable basis for the fear, is it reasonable? And in this case, the trial court recognized when it was admonishing both sides of the gallery that this was an emotionally charged incident. And Mr. Damon, who was the witness, had friends on both sides.
Does
So
Lewis depart from the general preservation rule that somebody needs to tell us, because we're not in a position to collect facts, what Mr. Damon would have said? In other words, did there need to be did the defense counsel need to elicit some type of a proffer from Mr. Damon as to whether his fears were objectively reasonable?
Judge, that would have been perfectly reasonable as an approach if you clear the gallery out. But if you don't clear the gallery out, you still have the same problem. He's going to get up there.
Can you do it at sidebar with the attorney basically just saying, Judge, I really want to elaborate on what I'm saying. 5 people came up to him in the hallway and threatened to kill him, and they're sitting right there in the first row?
Judge, you could do it at sidebar. However, the court shut defense counsel down. He immediately, without any inquiry, without asking defense counsel, just shut him down, said no. The first time he says, I would like to ask the court to empty the gallery so this witness could testify. He's in fear. And he just says no. He doesn't make any inquiry. And then as the witness takes the stand, he reminds the court, I still want this testimony taken outside the presence of the gallery. And the judge, so noted, just doesn't give him the opportunity to proffer it. And if he does proffer it with the gallery there, that furthers the fear that this witness has. And without that inquiry, Judge, you don't have a record. But it's the court's responsibility under Lewis to make that inquiry. And I'll give you another example of very important testimony that this guy was just too scared to recall. And it goes right to the heart of this case, the heart of Mr. Babble's sole defense, which was self-defense. The question was, did you have any discussions with Mr. Babble the night of the shooting? And the witness says, I don't recall. But in the deposition of Mr. Damon, says, yes, Mr. Babble was hearing that victim Sullivan was in town, who was from another city, by the way, was from Orlando, and he was looking for him. Babble was nervous about it. He was worried. He told me he had a gun, meaning Mr. Babble had a gun, and he was going to have to defend himself. That was critical testimony that goes straight to the state of mind of Mr. Babble that this witness was too scared to testify to. So it's our position, Judge, that was devastating to Mr. Babble's self-defense claim because the jury ultimately was deprived of that testimony. And it went straight to the state of mind of Mr. Babble, who was charged with homicide. So it's our position, Judge, that with respect to this issue, the court abused its discretion in not clearing the gallery or even inquiring into the witness's fear. And as the beneficiary of that error, the state, they're required to prove beyond a reasonable doubt that that error complained of did not contribute to the verdict in this case. So if I can move on, Your Honor, to my next issue, and this kind of dovetails straight into it. We believe that defense counsel was ineffective on the face of the record for 2 reasons. He failed to refresh that witness's testimony, recollection of previous statements that supported the sole defense that Robert Babble had, and he failed to object to the trial court's erroneous hearsay rulings. And while I realize it's not every case comes before the court with an ineffective assistance of trial counsel on direct appeal, it is well settled that claims of ineffective assistance are cognizable on direct appeal when the ineffectiveness is apparent on the face of the record. And in this record, the defense attorney filed the deposition of Alvin Damon. So we have trial testimony and we have the deposition that preceded the trial testimony. So we know what could have been used by the defense attorney, and we know what happened and wasn't used by the defense attorney. There are no strategic reasons for not knowing how to refresh a witness's recollection with a deposition or being unable to cite the simple state of mind exception to the hearsay rule. Those are not.
Fletcher, we don't know, obviously, because you're bringing this count on a direct appeal. We don't know all of the background and all of the potential impeachment that this witness could have faced if trial counsel had chosen to refresh the recollection. Is that correct? We just don't know the breadth of that at this point.
Well, Your Honor, I respectfully disagree. The witness was deposed. That deposition is in the record, and I will tell you that some of the most important testimony that was elicited by Alvin Damon actually was done by the assistant state attorney. And I can show you where that is if you want to see that.
Well, I understand that you can point to a deposition, but obviously at trial, we also have the issue of just pure impeachment, where counsel can use other means of impeachment as well, as opposed to just purely on deposition testimony. So we don't know the full breadth of all of the potential impeachment evidence that the witness would have been facing. And we really won't know that until we hear from trial counsel. Is that correct?
Judge, honestly, I disagree with that. The deposition, that's what depositions are for, to discover what we don't know. We have the entire deposition in the record. And defense counsel was not seeking to impeach this witness. This was his witness. He put him on in direct. He started asking him questions, and the witness started saying, "I don't recall." You can't impeach somebody with a deposition when they don't recall, when they say they don't recall. You just have to, judge, can I approach and refresh his recollection? You go through those foundation questions. Did you take a deposition on that?
Mr. Fletcher, your video is frozen up here. I don't know if anybody else is detecting. Mr. Fletcher, we've lost you. So the clock is not running at this point. I'm just waiting for, he dropped off now. We'll just hold on.
Judge, IT's trying to contact him now.
Okay, thank you.
You got,
I'm in on another phone.
we switched phones.
All right,
we-
Mr. Fletcher, we've got you back on the screen.
Sorry about that, Your Honor. I've been Zooming for months and just that's the first time that's happened to me.
That's all right, no problem. You've got about a little less than 4 minutes to go. That's including your rebuttal time. So I don't know if you want to continue or reserve the remainder for rebuttal.
Judge, I'll continue for about 2 minutes and just reserve a few minutes for rebuttal.
Okay.
Judge, as to the last question, it just appears to me as a trial attorney that this attorney who had a deposition full of very powerful evidence that goes to the state of mind of Mr. Bavel just didn't know how to refresh a witness's recollection, just didn't even try it. And as a result, after about a page and a half of testimony, he just says nothing further and sits down. Secondly, Judge, there were, in my additional point on issue 3 is as to the hearsay rulings. The defense attorney asked Mr. Damon, did Mr. Bavel ever tell you that he was afraid of Mr. Sullivan, the victim? And then the state objects, calls for hearsay. And although we all know that is a clear exception to the hearsay rule, but it's not even hearsay because it goes to the state of mind of Mr. Bavel, the court sustained the objection. And defense counsel never even tried to say, Judge, it's not hearsay because it goes to the effect on the listener. That was one example. Another example, did Mr. Bavel ever tell you, did you ever meet with Mr. Bavel and he told you that he was scared or worried? Objection, calls for hearsay. Again, it goes straight to the mind of what's going on in Mr. Bavel's mind. And it was relevant and it was admissible. The court sustained it and defense counsel just sat down, made no further efforts to get it in. That's not a strategic thing. He was trying to get it in. This is not strategy. This is ineffective assistance of counsel. So I would respectfully request that you reverse on all those grounds. And I'll reserve the rest of my time.
All right. Thank you, Mr. Fletcher and Ms. Davenport.
May it please the court. My name is Chris Davenport and I represent the state of Florida. As to the clearing the courtroom issue, let me note that in his reply brief, Mr. Fletcher says that the trial court was aware of the tenor of the trial. And that is exactly the point here. The trial court was aware of what that interruption was. We don't know on the record. It's written as indecipherable. We don't know if it was fans of the defendant cheering this witness. It was the first defense witness. We don't know if it was the victim's family making threats. We have no idea because it's not on the record. But the trial court knew what it was. And the trial court told the gallery that he wouldn't allow those kind of comments. As far as this threat to the defendant's mother, that was a Facebook message. They clarified that on the record. They brought in the person who made that threat, and he said to the prosecutor, it was a Facebook message. I didn't know she'd even see it. It wasn't a text as far as the record reflects. So you have this guy spouting off on Facebook. That's what trial counsel relied on below. He said, I have a witness. He's concerned about his safety. And in light of what's happened this morning, we'd like to clear the courtroom. That's all he said. And while appellate counsel says he was cut off, that's not in the record. He didn't say, Judge, I'd like to put more on the record. And the judge said, I've heard enough. There's nothing like that on this record. For all we know, there was a lengthy pause while everybody looked at each other. And then the trial court said, no, it's not the obligation of the trial court to make a better objection than what defense counsel presents. That's not how it works. And if he had more evidence, if he had a bunch of people who had threatened the guy that morning and they happened to be in the courtroom now, he should have said that. And presumably he would have said that if those were the facts. We certainly can't assume he was blatantly ineffective and had a bunch of threats against this guy, but chose not to tell the court about it. We can't assume that. That's not how the system works. We assume that they put everything on that they have. And then maybe in a 3850, he would say, gee, I was just so shocked that he said no. It didn't even occur to me to present all of these threats he'd gotten. But we certainly can't do that on direct appeal, which leads into point 3, the ineffective assistance on the face of the record. Yes, the witness was much better in his deposition, as witnesses often are, but that's not ineffective to not present it. He said some pretty damaging things to the defense in that deposition too. Maybe defense counsel didn't want to bring out the deposition and have the prosecutor say, gee, I'm going to refresh some things too. In the deposition, the witness said that victim was a gentle guy. He's not dangerous. He had a falling out with the defendant's mom because he was mad at the defendant for shooting the guy when he was really gentle. And the guy was being a jerk about getting the gun back, but he didn't see him as a threatening person or a dangerous person. That's pretty damaging evidence to be brought in front of the jury. So that deposition wasn't purely gold for the defense either. But we don't, appellate counsel says that defense counsel didn't know how to refresh a witness's recollection. That is a bold statement to be making with no record support and no opportunity for trial counsel to say, of course, I knew how to do that. I had a nervous witness or an uncooperative witness, or I saw how the jury was viewing him. There are all sorts of things that go into these decisions that we can't see on a cold record. That's why they have hearings at a 3850, and that's where you bring these kinds of claims. We can't do it on a record like this. If the court has no questions, I would ask you to affirm. Thank you.
Thank you, Ms. Davenport. Mr. Fletcher, you have about 2 minutes, a little over 2 minutes.
Thank you, Your Honor. Your Honors. As far as the tenor of the trial, Judge, this was a homicide. It's a crime of violence. We do know that the gallery was boisterous. There were threats made to the defendant's mother. It's not my obligation, and it wasn't defense obligation below, to show that there was some kind of nexus between what was happening in the courtroom and what Mr. Damon was fearing. What defense counsel's obligation was to bring to the court's attention that his witness was in fear for his safety. And he did it twice, and the judge just shut him down and didn't do the inquiry that he was required to do under the Lewis case. That's all defense counsel has to do. That's our position, and it was prejudicial. It's obvious on the record to us because of the way the witness testified. Appellee's counsel engages in a lot of speculation. The deposition is in the record. The court can review that. Not everything in that deposition is admissible in this case. The statements that went to Mr. Bavel's state of mind and what he was told about the threats from Mr. Sullivan and to his mother, those are all admissible because they go to the state of mind. What Mr. Damon thought of Mr. Bavel's mother has nothing to do with the case, and it would not have been admissible. Just because it's in a deposition doesn't mean that the other side can put it into evidence. So I would stand where I was and say that this case should be reversed because there were no strategic reasons at all. There could be none. And there was ineffective assistance on the record, and it prejudiced Mr. Bavel. So I'd ask that the court reverse.
All right, counsel, thank you for your arguments. And at this point, this is the last case we have on the docket this morning, and we are adjourned. Have a nice day.
Thank you, Your Honor.